Okay, three very important things that you should know about a last will and testament. So a will, commonly referred to, a will, who gets what of your stuff after you pass away. Wills serve a purpose. Sometimes they can be important. They're a valuable piece of estate planning, but generally for most people, we're probably not going to recommend that all you have is a will. But three things that I think are common misconceptions, and probably three of the most important things that you should know. Number one, they don't avoid probate, right? And this is where a lot of people don't realize this. A lot of times someone will do a will saying who gets what of, let's say, mom does a will saying who gets her house when she passes away. She leaves it to her kids, gives them a copy of the will. She dies. They go to the courthouse, to the property appraiser with a copy of the will. They say, look, mom left me the will, left me the property in the will. And unfortunately, they're going to refer them to a probate attorney, because if the property was just in mom's name, then they're going to have to go to probate to transfer title to their name. Because remember, when she died, even though she had a will, the house was still in her name. So she can't, now that she's passed away, she can't sign over the property to her kids. Even though the will says she's going to get it, the kids are going to get it, they're still going to have to go to court in order for the judge to allow them to change title in their name. So really, really important where we see this, people just are frustrated, don't understand this. If all you have is a will and all of the assets, the house, the money, the bank accounts, those don't have beneficiaries, and the owners on those accounts, or the owners of the house is the person who passed away, probate's most likely going to be necessary. Number two, wills are not generally recorded, right? So a lot of times someone, they might do the will themselves. So they go to Office Depot, they go to one of these online legal services, they download a will, they print it out, they handwrite it, they fill in the blanks. If they don't tell anybody where the will is, nobody's going to know that a will has been recorded. Or even a lot of time at the attorney's office, they might go do a will. For example, our standard procedure is we'll give back the original to the client, but we'll keep an electronic copy. But if that person passes away and their family members don't know that they had a will, don't know, who their attorney was, then most likely they're never going to know there was a will. So there's not really, or not generally used these, a database where all wills are recorded. So you want to make sure that somebody at a minimum knows that you have a will, knows where you have it. And three, probably most important, or very important, is each state has certain requirements of what makes a valid will. And so, speaking specifically to Florida, generally it needs to be signed by the person, and there needs to be two witnesses. It doesn't generally have to be notarized. That's a good idea to have it. There's some language in there that you probably want to have called a self-proof affidavit, but the requirements are relatively minimum. Oral will, so you're just telling someone you're leaving someone something, is probably not going to be allowed, at least in Florida, it would not. So, again, especially if you're doing a DIY, do-it-yourself type will, you want to make sure that it complies with whatever state you're going to be residing in or where you have assets in. So those are probably the three most important things where I see a lot of people get messed up on or confused about. Just follow the requirements of the state. They're not going to be recorded, so that's something to pay attention to. And importantly, if one of your goals is to avoid probate, a will by itself is not going to do that.